Our second speaker is David Morris, who's also a private attorney. David brought one of the most significant cases in the landlord-tenant area in this state, Lawrence versus Regent Realty, which established some very important rights that tenants attorneys have to attorney's fees. David is going to speak about representing tenants as plaintiffs. David?
My name is David Morris, and Paul has discussed eviction defendants also being counter plaintiffs in landlord-tenant cases. My remarks are going to focus on tenants as initial litigants in court. There's a threshold matter that I'd like to bring up. Actually, there are two. The first is that the outline that was provided with today's seminar, the pages were miscollated. So I think that if you pull out the staple and sort of look to where you can see in the outlines that they appear to belong together, you'll be able to follow a little bit more easily, because I think that some of them are interspersed between the various speakers. I'd like to discuss a common presentation that comes in from tenants that really isn't going to be addressed by anyone else today, but I think it's an important thing for attorneys representing both landlords and tenants, and that is withholding rent opportunities that are provided for tenants. Really, there are several opportunities in which a tenant could withhold rent when the landlord is in violation of some right that the tenant possesses. First set are really contained, they're in my outline, actually set forth all of the ones that I found in the landlord-tenant ordinance. Under the RLTO, which I'll refer to as the Chicago Residential Landlord-Tenant Ordinance in my further remarks. The other is that there's a right to set off for any of the other damage provisions that are provided in the ordinance. If there's failure to pay interest 1 year and there's a violation, automatically the tenant's entitled to 2 times the amount of their security deposit. They can use that as a set-off in any future term of their rental. They can also have rent set-offs for common law claims such as implied warranty of habitability under the Spring case. I advise pretty uniformly never to advise every tenant never to do it, and I'll tell you why. Although these opportunities are even specifically provided for in the ordinance, I think tactically or strategically it's a tremendous mistake to do that. First, your tenant follows all the rules, sends the 14-day notice. There's bugs. As a result, I'm going to start withholding rent 10%, 15%, whatever they determine is appropriate. That's immediately followed by a 5-day notice to evict them by the landlord. And that 5-day notice is filed in short order by an eviction complaint. Your client is now facing homelessness as their first consequence of having followed the law in this regard. There's also a potential effect on credit reports. There are credit reports that are targeted specifically to landlords, and I'm not certain about this, but I think that they may even pick up eviction complaints that don't result in conviction. And if they do result in a tenant's rights being vindicated, think of how that looks to the next landlord. Not only is this tenant someone who is subject to an eviction by the landlord, but then they won. Is that the kind of tenant that a landlord would like to have renting from them? Probably not, if they're aware of it. Finally, as Paul pretty compellingly pointed out, the eviction court is about the worst forum for adjudicating your tenant's rights. Most tenants do, unfortunately, fail to pay for economic reasons, which results in judges that are in fact hardened to tenant positions with regard to their claims of a right to set off or the reasons why they didn't pay the 5-day the full amount contained in the 5-day notice. And there is the less than 2-minute time period that a tenant is given to explain their entire defense in this case. And there's the possibility that the landlord will, after even listening to it properly laid out, will just say, well, how much time do you need? Finally, how much do you withhold? There are no guidelines in the ordinance. There's no guidelines in common law. there's no way to determine exactly how much the tenant's supposed to withhold. People might say, well, I didn't have heat for a month, so I withheld all of my rent. And that may sound very reasonable to most of us here. If you're in December and the temperature outside is 12 degrees and you don't have heat for an entire month, really, should you have to pay anything? But the judge's point of view is, if you're still there, the tenancy must have some value. If you misvalued how much you're withholding, you're going to get evicted. And there's no way to know what that amount is. And so, for all of those reasons, I think it is a very bad idea to withhold rent, even as provided under the ordinance, or for any other reason. Instead, by contrast, in an affirmative case, where the first allegation in your complaint is going to be, I did everything that I was supposed to under my contract. Now, here's what the landlord did wrong. And I think that's compelling to a trier of fact to hear that it's the other person that did something wrong. You may have to work around some practical issues such as the voluntary payment doctrine, and you pay under protest, you send a letter, you indicate that you believe that you have the right to withhold 30% of your rent that month because the landlord has never gotten rid of the bugs that you've been complaining about, and you've got children that are having bugs crawl over them at night. Please let me know within 5 days if that's acceptable. Of course, no landlord is ever going to say that that's acceptable, and I think the consequence, if you withhold it under those circumstances, is going to be the coercive eviction, which gets you out from under the voluntary payment doctrine. Now, if you can find an attorney such as Paul or someone else that will defend you in an eviction case after you've withheld your rent properly and willing to go through with it right at the outset, then perhaps you can do that. But unless you have someone guaranteed, lined up, ready to go to bat for you before you start withholding the rent, I think it's a real bad idea to do it on your own. And if you can find an attorney such as Paul willing to do it as a defense or as a counterclaim in an eviction action, you should be able to find an attorney willing to do it as an affirmative matter in the first place, where all those potential detriments and consequences that I pointed out would not be a problem. Now, the number of affirmative claims are really limited only by the imagination of the attorneys that are bringing them. I've identified a number of particular areas, practical nuts and bolts within the RLTO that you will find is useful